Much for your time and good morning to you.
Good morning, and very good morning to your cherished listeners.
I hope you're well.
I'm recovering quite well.
Mm, okay.
Thank you for your consistent concern.
Mm. A few things to understand here. Is it irregular for a lawyer to write to a court asking that I am not in the jurisdiction you're about to deliver judgment, or maybe here a matter that I'm in, kindly defer it until my return?
All right. Once again, thank you so much. The court is a place where a certain level of decorum, respect, is required, not just on the part of judges, but most importantly on the part of lawyers. Lawyers to judges, and even between or among lawyers at the bar. And so, where a matter comes before a court of competent jurisdiction, and the matter has traveled to the extent of judgment being about to be delivered, we have very few or limited circumstances under which the delivery of the judgment may be deferred or postponed. And in the case of the instant matter, you notice that it is a matter of high public interest. And therefore, a judge in delivering a judgment of that nature is also guided by the public perception and the public expectations of the conduct of not just the lawyers, but the judge as well. To the extent that the judge doesn't really owe any individual any explanation as to when he wants to deliver his judgment, they are also guided by the fact that whatever is being done should be done in such a way that it reflects optimal justice in the administration of justice generally. And so, the classical case that we have before us now is one that is highly political in nature. And so, that is fundamentally guiding the judge's actions and inactions. That is not to say that she may be afraid or scared of anything, but she's only guided by the fact that it's a matter that must be determined in such a way that there can be no room for any form of speculation aside purely the law. And so, because there was an initial lawyer on the matter, at which point judgment was just about to be delivered, and the lawyer had to withdraw from that case, a new judge taking over the matter naturally will want to bring himself to speed as to the state of affairs as far as the matter is concerned. And that's exactly in the spirit within which judgment may be deferred or postponed to a later date. And so you notice that the judge obliged the judgment to a later date just to afford the lawyer the opportunity to acquaint himself so well with the nitty-gritties of the matter and see even if there were some legal interventions he could make legitimately to ensure that justice was not just seen to be administered, but manifestly what? Administered. And so that was the essence of all that happened as soon as lawyer Atache took over the matter. Now, where a matter is in session or in progress as we have it now, it is not also a very good ethical practice on the part of a lawyer to travel out of the jurisdiction only to write a letter at the 11th hour indicating that he or she is not available and therefore judgment should be postponed until such a time that he or she will be back in the jurisdiction. That is not an appropriate practice, even though it is acceptable for a lawyer to write formally to a court to excuse himself, for which reason a later date may be given to him to appear on the matter. But mind you, lawyers do not work in isolation. We only have few instances where somebody may be working in isolation. That is solo practice. And therefore, if there's nobody in his or a chamber to take over or to assist to by way of holding brief, then naturally the judge most likely will oblige so that he comes back to handle the case himself. But in this case, we are talking about Atachia. We know Atachia is operating a law firm together with other people you may consider competent, and therefore there's no reason to want to hold into Atachia at all costs to be in the matter. That's legitimately what it is now. But for some reasons, he may also want to be personally there. But if you want to be personally present to see to matters, you don't put yourself in a situation where it paints a certain negative image about you, and therefore to give a general impression that you are simply invoking a certain delay tactics for which reason you are doing all these things. And so all I'm trying to say is that to the extent that that is permissible, it's not of a general or universal application, where especially it is influenced by abuse. And that's exactly what I see in this case. You know, if you monitored closely, people indicated that once Atachi had taken this matter up, he was going to be applying delay tactics, and that is notoriously known for delay tactics. You know, even though technically we try to do that sometimes just to buy some time, but ultimately judgment will be delivered. But it doesn't also augur so well when you do that, because you create a certain impression in the minds of not only the judges, but colleague lawyers. And therefore, where you even have a legitimate objection or application to make in a subsequent matter, by the impression you have created and the perception that people have developed about you, it goes against you in practice. And so that's the sad aspect of it. But as it stands, he has given an indication that he's out of the jurisdiction. And at what point did you leave the jurisdiction? Even if you are writing, the judge, for that matter, will expect to see a genuine cause, a legitimate grounds or reason for which you will be unavailable for the matter. That hasn't been said. He just said that he's probably out of the jurisdiction on personal engagements. But you don't sacrifice your client's your client's case for your personal engagements, especially when it borders on a critical matter like this. Everybody will reason out that it's simply a delay tactic. You knew about such arrangements, personal arrangements, but then you were also well known ahead of time, the time or the judgment date. It was well known to you ahead of time, and at that point you couldn't have even pleaded with the court that on that date, that date, you wouldn't be in the jurisdiction. If you had done that on that day, the judge would have obliged you by giving you a more appropriate date. But you don't allow the judge to give the date, then you agree. And when the date is now due, you now write to tell them that you are not. Clearly, you don't need to be a lawyer to know that this is a delay tactic. And that is, unfortunately, what we are going through now. Is not an acceptable practice. And that is not serving the interest of the client as well.
Okay. But so you're saying that the judge can ignore this letter, give judgment on, because we are hearing that he's already ruled on that application, the application as to whether or not the case to be adjourned, and then go ahead to give the main judge, to deliver the main judgment on the matter.
As for judgment, once it's ready, it can be delivered. But like I said, the judge might only be doing so because it has a certain political a light all over. And so he's trying to avoid a situation where, in the event of delivering the judgment, a certain claim may be made, which then brings his integrity on the line. Otherwise, there's nothing preventing him from going ahead with the judgment. What matters is that the judge is well clothed, or the lawyer for that matter, Atacha, is well clothed with all the facts of the case. They have actually made all the relevant submissions, all the necessary documentations have been filed, all processes have been filed, and those that are required to be heard have been heard, just like you are giving me this information. If it has been heard and was refused, then the way is paved, and therefore judgment can be delivered. As long as the client is available, it can still be delivered. If there's anything that you think it makes you so dissatisfied, you know the processes to invoke. Yes, you go by the legal processes. And so the judge in this particular instance, it's just being generous or meticulous at the same time, and try to make sure that, just like in a criminal case, avoid every single doubt in the course of attempting to deliver his judgment, so that nobody holds anything against him or her. That's fundamentally what it is.
I see. So it's possible we'll be getting judgment on the matter today.
I didn't hear that.
I'm asking whether then it will be possible we can get the final judgment
Is it
today.
possible to?
It is possible we'll get final judgment today.
Wow, too bad. The line keeps
slipping. Can you hear me now? La?
Can you hear me?
I can hear you clearly. I'm wondering if you can hear me.
Can you hear me?
Wow. So Black cannot hear us any longer. But okay. I think the point is well made. He is saying, when the judgment is ready, the judgment is ready. It can be arrested through some means, but maybe this may not be one of those instances when you can easily arrest judgments. There are those